Supreme Court judgment. Some senior lawyers want post-election cases decided before elected officials inaugurated into their offices. Good afternoon, good evening, good morning, depending where you're watching this video from and the time you're gonna see this video. I remain my humble self, the Aikma. If you're coming across my page for the first time, I would like you to share my videos. Drop your comment at the comment section. Give the videos a thumbs up. Remember to subscribe to my YouTube channel and also follow me if you have not done so. These particular issues have been discussed in so many cases by so many people, by so many lawyers as well. Some in the view that in any election cases that arises after any election should be determined before that the person INEC has announced as the winner being inaugurated into office. Reasons: if the person is being inaugurated into office, knowing the kind of society we are and the kind of country we have, that person will use the incumbent power, will use all the power he has or she has to influence the particular case in court, which is the gospel truth. One of the most senior lawyers I respect enough, Femi Falana, has also made this assertion sometime in an interview where he also said the same thing, that the 180 days given to these election cases is too much to determine this. It should be done before the inauguration so that the person that INEC has declared will still be out of office and will not have any right to influence anybody. I think this is how the thing should be. But sit tight, let's look into this, because some other people also are talking about the constitution. The same constitution that have kept us in this particular way we are today. The Supreme Court judgment upholding the election of President Bola Tinubu has left lawyers divided on whether election cases should be concluded before the swearing in of the elected officials. Some senior lawyers want post-election cases decided before elected officials' inauguration to avoid wahala, especially from presiding judges. But others held that the period provided by 1999 Constitution as amended is enough to treat election petition, not minding whether it ends before assumption of office or not, which is 60 days. According to Section 285 of the 1999 Constitution, an election tribunal shall deliver a judgment in writing within 180 days from the date of the filing of the petition. Section 285(5)(7) provided that an election petition shall be filed within 21 days after the date of the declaration of result of the election. An election tribunal shall deliver e-judgments in writing within 180 days from the date of the filing of the petition. An appeal from a decision of an election tribunal or court of appeal in an election matter shall be heard and disposed of within 60 days from the date of the delivery of the judgment of the tribunal or court of appeal. 140 days. Both the Presidential Election Petition Tribunal (PEPT) and Supreme Court spent 140 days handling the petitions tendered by People's Democratic Party (PDP) candidate Alhaji Abubakar, Labour Party flag bearer Peter Obi, and All People's Movement (APM). In the end, the Apex Court affirmed Tinubu as the valid winner of the presidential election held on February 25th. Given suspicions and usual trial, the outcome of such judgments in favor of any incumbent and fear of a wahala of interest, lawyers in conversation with Sunday Vanguard gave their opinion on the way forward. Aberration. A legal luminary, Professor Awokalu-san, said, ideally, when you have a contest for the highest political seat in the country, even at the state level, it makes sense to clear every electoral hurdles, including litigation, before the winner take the prize. If you are running a race, 100 meter, 400 meter, 1,500 meter, whatever the type of race or competition. Ordinarily, you finish the competition before somebody pick up the prize. So it makes sense even in politics for any competitor to pick up the prize after the race. It is not when the race is still on. Somebody already has the prize. It makes it difficult for the umpire to say, give us back the trophy. Let us present it to another person. That certainly is an aberration. So I recommend very strictly that we should finish the race before the title is won. So when somebody appropriates all the power, whether as president or as governor or as a member of the legislature and so on, let the totality of the competition be over before presenting the trophy. That is my position, and there are my reasons for including the points I have just made. If you present a trophy and you restart the competition, even the referee will be shying to say, Oga, bring back your trophy so that we can give it to the person that has won. You will hear it even in commentary that it has never happened before. How do you remove a president, governor, or whosoever? I believe it makes sense. It makes for fairness to keep the trophy. Let all the competitors look at it, and when somebody has won the race, let the winner pick it up. That is the way to go. It is not when somebody is already a president, a governor, or a legislator that you start litigation and he now uses the weight of his office on you people. Also speaking, Mr. cti0n said the call for election petition to be concluded before swearing in is worth looking into. He said the agitation to have an election petition concluded before swearing in is worth looking into. If that should then be the case, our electoral act will have to be amended to have more time for preparation and holding of election that will allow the 10-month period for electoral litigation to be concluded before the swearing in of newly elected officials is done. The meaning of the above is that we need to bring the time for holding the election closer or clearer at least 10 months before 29th day of May of the election year. Holding the election 2 or 3 months before the swearing-in date cannot guarantee conclusion of electoral cases before the handover date. That's if they want to follow the constitution. However, I believe that what we need most is the need to ensure that elections are free, fair, and transparent. The National Assembly has tried with the various provisions enacted into the Electoral Act 2023. We need to ensure that we create a greater guarantee of election being held in peace and with minimized possibility of undue manipulation and interference. By my assessment and based on the report by the Election Monitoring Committee of the Nigerian Bar Association, which is my professional constituency, I believe the 2023 election were freer and fairer than some elements would want the world to believe. Okay, now, that is not to say that the electoral process is perfect. However, if the agitator would be more relaxed through ensuring the electoral litigation is concluded before swearing in, I think there is nothing wrong with the idea. It is the possibility of claiming freer navals. Upper hand, a senior lawyer, Mr. Ebenezer, said election petition in court should be conducted before swearing in, adding that any candidate that is returning as a winner of an election already has an upper hand. His word, the truth is that decision of the Supreme Court from the appeal filed by the appellant to the decision of the Presidential Election Petition Tribunal, PEPT, at the Court of Appeal is appellate. It is not surprising that the Supreme Court unanimously upheld the decision of the Court of Appeal. It doesn't mean that the petitioner didn't have a good case, but when talking of justice, there should be justice for both parties, the people and for the court. Justice is isn't a one-way traffic thing, it is four-way traffic. We don't need to be told that election petition in court should be conducted before swearing in, because any candidate that is returned as a winner of an election already has an upper hand. He has an advantage over other candidates because the candidate contesting his return as the winner of the election have an uphill task to prove that there was no substantial compliance with the Electoral Act. It is better that there is no swearing in before election petitions are concluded. None of the candidates will have an undue advantage over the candidate contesting his return. We need a lot of amendments in our laws if you want to improve. These are the things these people are thrashing out, and which is very important for us to look into. 3 months. On this part, Professor Paul Ananabasan said the Electoral Act should be amended to address the issue of Section 137. That section is what the tribunal understood to mean there is no money to call evidence in each polling unit. But the way the law is as per the judgment, witnesses will be called in virtually every polling unit. That law should be reviewed to bring that thing to an end. We cannot spend years trying to call witnesses. The time for election petitions should not be more than 3 months. All our elections should be held on or before the last day of February. We will have March, April, and May to decide petitions. The onus of proof should statutorily be on the Independent National Electoral Commission. INEC alone should defend election. This was exactly what Femi Falana was also saying. The INEC are the one that should defend what they have conducted, whether they did well or not. We continue. Election petitions should spend 6 weeks at the tribunal, 3 weeks at the Court of Appeal, and 3 weeks at the Supreme Court. Every election petition should have been decided on or before 26th May. That way, we will have a sane situation. Transparent election. Giving his view, Olu San urged the National Assembly to amend the Electoral Act 2022 to have transparent election. His word, the Supreme Court held that failure by INEC to upload election results on IREF lead to loss of public confidence in the electoral process. The court, however, held that such failure will not lead to the nullification of election results. The judgment is sound in law and accord with the relevant statute on the issue. What then is the penalty for the electoral umpire that failed Nigeria upon his voluntary undertaking? It is left for the National Assembly to amend the Electoral Act to give us transparent elections. We cannot continue in this fashion. Thank you very much, guys. I remember my humble self, the Ike Man. Seriously, there are many things that need to be amended in our constitution. Some of the things that are not going well today in our country is based on the kind of constitution we are using. I think there should be serious amendments in some of the things we have in our constitution. Thank you very much. We move regardless.